Hello everyone, my name is Andrea Navarro and my teammate is Samantha Garrity. We have been tasked by our supervising attorney to research the following facts. A client comes into our office and relates the following facts. She purchased some land in 1989. Her deed showed a 20-foot access road from a main roadway to her property. The roadway to her property crosses Smith's property. Smith acknowledges the client has been using the wagon road since purchasing her property. However, he claims he never gave her permission to use the road to access her property, and she never asked for permission to use the road. However, he never told her that she was not allowed to use the road. Smith has sued the client, alleging that she's been using his property without permission. Our attorney wants to know if there's any relevant case law that will allow the client to get an easement to continue using the roadway. For my research, I'm going to use LexisNexis. On the start page, I'm going to start by going to State Court Cases Combined, and I am going to enter, I'm going to go to State Legal US to Texas down at the bottom, and then I'm going to go to Texas State Cases Combined because I want to focus on Texas. That is my my state of choice. I'm going to then enter the words, because I'm looking for relevant case law that allow the client to get an easement to continue using the roadway. I want to see if there's any state decisions first, and then to see if any federal court cases address this state decision. In the search box, I'm going to use natural language and enter the words easement, egress, in the state of Texas. Then I'm going to hit search. It brings up 100 cases, which is a lot of cases to look at. So in the focus term, in the case she talked about permission, so I'm gonna put in there permission. Because she wasn't granted permission, and that's what the client is arguing, that they never gave the person permission. And then when we do that, we bring up 23 cases. In those 23 cases, I'm going to focus on Lexis has these little icons right here to tell you if it's good case law or not. So I try to stay away from the yellow and red. But I did find a case that I did like, which was I kind of look over the core terms to see if anything catches my eye. Rosier versus Othen. And then Rosier versus Othen, a neighbor's land, they were interlocked, and he was entitled to an easement across owner's land to a public road. The owners were enjoined from interfering with the neighbor's use of the easement. And the court affirmed this part of the judgment. This is good case law. So what I'm going to do from here is I'm going to download the case. I can get it to download. Word document. So I'll download it, and it's formatting it. It's 6 pages long, and it's ready to click open. So you click it open, and what we get is Rosier versus Othen. And the specific case law that answers the question is the overview. Since Smith acknowledges the client had been using the wagon road since purchasing her property. However, he claims he never gave her permission to use the road to access her property, and she never asked for permission to use the road. However, he never told her that she was not allowed to use the road. In this case, the neighbor's land had no access to a public road, and he claimed that he and his predecessors openly, continuously, and uninterruptedly used a roadway across the owner's land to reach a public road for more than 40 years. On appeal, the court found that the trial court correctly found that a necessity existed for the continued maintenance and use of the easement, and that the trial court properly issued the injunction. The neighbor's land was interlocked and required an easement. The owner's land was the most feasible and practical means for travel to a public road. However, the court found that the order to put the it talks about a separate issue where this specific case, they put up a levee and closed down the easement. So the court wanted to force the owner to shut down the levee and rebuild the easement to a usable condition, which a court couldn't force him to do that. What they could say was that easement, the court affirmed the part of the judgment that establishes the easement over the owner's land, and that they enjoined owners from interfering with the neighbor's use of the easement, that they couldn't keep the neighbors from using the easement. The use by permission in such cases, in absence of proof to the contrary, may be presumed, meaning since they had used it, a long continued use of the roadway or easement right does not in itself raise a preemptive way of necessity across a stranger's land, but the use by permission in such cases, in absence of proof to the contrary, may be presumed. Where a claimant shows an open, visible, continuous, and unmolested use of the roadway on and across the land for another for more than 45 years, and the facts of the situation are such as to impress the view that the way is the only feasible route for the claimant to reach his home and market or public road, as here the right of use as a matter of necessity should not be disturbed. So in this case, because it showed that they agreed with this case, and it's a good case law. They concluded that judgment of the trial court established the easement and enjoining defendants from interfering with plaintiff's use for ingress and egress not inconsistent with the defendant's use is affirmed. And that is why I chose Rose Sierra versus Othen, because it talked about how, even though they may not had clear permission, use of it for a long time, with nobody ever saying anything about it, kind of like presumed permission. Thank you.